Welcome to another exciting episode of Unraveling Intellectual Property with Michael Stein. Today, I have a very good colleague of mine, Allen Zhou. And Allen is a partner and chief counsel at INRI, is that correct?
Yes.
Okay, INRI IP Law, where he works closely with international clients to protect and enforce their intellectual property rights in China and with Chinese companies to find the right foreign associates for IP matters overseas. His practice spans a wide range of services, including patents and trademark applications, dispute resolution, e-commerce platform complaints, including Amazon, and international enforcement consulting such as ITC 337 matters. Welcome, Allen.
Hi, Stein. Hi, Michael. And hi, audience of YouTube channel of Stein IP. And thank you for having me today. A great pleasure here.
Well, excited to have you. Can you tell us a little bit about your law firm?
Well, sure, of course. I work in INRI IP, and INRI IP Law is an international property law firm dedicated to protecting and advancing the IP interests of clients worldwide. So I work in the international department here. We have clients, not just the domestic, but also the overseas clients. And for example, their IP layout here in China and IP related consulting and etc. etc. And our slogan is "Enrich for your IP interest." It's our jobs to help our clients for their IP protection here in China.
All right, sounds great. Today we're going to be talking about patent prosecution in China. And I know you're the expert. So how does the process get started? Someone says, I want to file a patent application in China. What's the beginning process?
Well, thank you for your questions. And to get it started, I would like to say that at least you need to learn about what are those type of pattern here in China. So I know in the United States, you guys have the utility pattern, you guys has the plan pattern, you guys has the industrial design, but there is a little bit difference here in China. So first, there is invention pattern, which is the same as the utility pattern in the United States, but we do not have the plan pattern here in China. We have the plant protections in China, but not included in the patent system. So the second type of patent here in China is utility model, which is also used to protect the technical solution. But I want to say there is a big difference there because they granted much more quickly and without substantive examination. I believe there were two main reasons why utility model exists here in China. The
But
first
just
one
briefly, so you're telling me that there's no examination process at all?
there is no examination
Okay,
process
so
at all
it's
for the utility
purely
model.
a registration process.
Yes.
Okay, I'm sorry. Go ahead. I didn't mean to interrupt you.
Okay, sure. So, uh, to keep it going, I want to explain a little bit more about the utility model. So, why there will be like utility model here in China? I think there are two major reasons. The first one is historical. So, China's patent system was first built in the 80s, and at that time, a lot of ideas were borrowed from the Germany system, actually. Yeah. Back then, many countries, not just China, for example, French and Japan, looked to Germany approach as a reference. Over time, of course, each country has developed its own path, adapting the system to fit their legal and economic context. The second reason is more practical. Utility model here in China is are especially useful for protecting small technical improvements, particularly in mechanical field. As you know, China is a major manufacturing country. A small improvement to a machine or a device can lead to significant cost saving or efficient gains, and can even boost an entire industry. So, from an economic angle, I would like to say that utility model will still exist in China for a really long time.
So, but
And
so why would anyone go for what's the other one, the stronger one?
the stronger one is the invention patent, same as the utility
Utility.
patent
Okay,
in the
right.
United States.
And so
Yes.
why would someone go for that? Do you get better protection? Do you get better presumption, better damages?
So, as I said, for example, the utility model, it can be used to protect technical solutions, right? But for the utility patent, same as the invention patent here in China, you guys can use it to protect like the drugs, the soft programming, those kinds of topics. But the utility model cannot be used for that.
All right.
That is the difference. That is the difference. Okay.
But
Yeah, the third type of pattern is the same, the design pattern, same as the one in the United States. Also, the difference is here in China, for the design pattern, we do not need to go through the substantive examinations.
all right.
Yes.
Oh,
So,
an application, yeah. An application can it be filed in like in the United States, you can file in another language, but you need to file a translation. In China, does it have to be filed in Chinese?
yes, of course,
Yeah.
you have to file the Chinese application in Chinese languages.
All right. And then uh what how long does the examination until you get like a first office action? I would assume it's somewhat similar to the United States, the process, or totally different. Can you elaborate on that?
Of course, of course. For example, for the utility pattern in the United States, you guys need to wait for like 1 years or 1.5 years
One
to
year
get
is
the first
optimistic. Yeah. Yeah.
to get the first office action. So
Right.
here in China, similar but a little bit different. In China here, you need to wait after 18 months for the first office action, right? The 18 months is for the publication, and after the publication, you still need to wait like 4 to 5 months for the first office action. And then keep doing the action between the CNIPA and your examiner. It will be for like 2.5 years to get your patent granted here in China.
So let's say you file in the US and you file within China in a year.
Hmm.
So it's going to publish in 6 months. Might the examination be sooner or there's no sooner examination?
The Good question. Good questions. The calculation actually is from the first filing date. So there were a lot of US clients, they first filed in the United States, and then they filed their Chinese application through two different routes. The first is the Paris Convention, and the second is the PCT route, right? So the calculation is calculated from the first filing date in the United States. So uh, after 12 months, you file the Chinese applications, and then you only need to wait 6 more months, and then you will probably get the first of the actions. You're correct about that.
Just as far as your practice, do you file more PCT or Paris Convention or
Um, I got to say it depends. It depends. For small or medium clients, they already have the business structure, I would like to say that, in their brain, in their mind, and then they might want to pick the more price competitive way, for example, the Paris Convention. But for those giant, industrial giant, they want to file in different countries, not just China, and then they might just want to pick the PCT because you know that for the PCT you have like the 13 months to use for your IP layout.
All right, well, let's take a quick break. This is the end of part one. Please, everyone, stay tuned for part two. We'll cover a little bit more on the patent prosecution, but then, Alan, I also want to talk to you about enforcement and the strength of protecting your assets, IP assets in China. Okay, everyone.
Okay.
Thank you.